At this time, I'd like to call this meeting to order. Good evening, everyone. Today is Thursday, June 8th, 2023, and this is a meeting of the Rent Stabilization Commission for the City of West Hollywood. We would like to begin by acknowledging that the land on which we gather, currently known as the City of West Hollywood, is the occupied, unceded, seized territory of the Gabrielino Tongva and Gabrielino Kizh peoples. I'd like, I would like to ask the council member Chelsea Byers if you would lead us in the Pledge of Allegiance. It would be an honor.
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. All right, Commissioners, the first item will be the oath of office, and we will administer the oath of office for two Commissioners, Josh Kurpis and Kellen Martz, and we're honored to have Council Member Chelsea Byers here to administer the oath of office. We haven't done this for a long time.
We're just pulling up the oath. I can't find it. Sorry.
Let me grab it. I can either email it to you or I can print it. Yes. No worries. No worries. I'll send it over to you right now. Yes. I'll be routing it to you over DocuSign. Yeah. And I have the break center ready for it. Okay. I just sent it over now. Yes.
It's been a while.
Shows, I see it on my set box now. Okay, perfect. Okay, thank you.
I unfortunately don't have it memorized yet. Okay. So you will raise your right hand and repeat after me. I state your name.
I, Josh Kurpis,
Do solemnly swear
do solemnly swear
that while serving in the office
that while serving in the
as
office
a member of the Rent Stabilization Commission
as a member of the Rent Stabilization
of,
Commission
of the City of West Hollywood,
of the City of West Hollywood,
that I will support and defend
I will support and defend
the Constitution of the United States
the Constitution of the United States
and the Constitution of the State of California,
the Constitution of the State of California,
that I will bear true faith and allegiance
that I will bear true faith and allegiance
to the Constitution of the United States
to the Constitution of the United States
and the Constitution of the State of California,
and the Constitution of the State of California,
that I take this obligation freely
that I take this obligation freely
without any mental reservation
without any mental reservation
or purpose of evasion,
or purpose of evasion,
and that I will well and faithfully
and that I will well and faithfully
discharge the duties
discharge the duties
upon which I'm about to enter.
upon which I'm about to enter.
Congratulations,
Thank you.
Commissioner. Thank you.
Next is Kellen Martz.
It's the same thing, so it makes it easy. Hello.
How are you?
Good.
Good.
Good. Okay. You'll raise your right hand. Repeat after me. I state your name.
I, Kellen Martz,
Do solemnly swear
do solemnly swear
that while serving in the office
that while serving in the office
as a member of the Rent Stabilization Commission
as a member of the Rent Stabilization Commission
of the City of West Hollywood,
City of West Hollywood,
that I will support and defend
that I will support and defend
the Constitution of the United States
the Constitution of the United States
and the Constitution of the State of California,
and the Constitution of the State of California,
that I will bear true faith and allegiance
that I will bear true faith and allegiance
to the Constitution of the United States
to the Constitution of the United States
and the Constitution of the State of California,
the Constitution of the State of California,
that I take this obligation freely
that I take this obligation freely
without any mental reservation
without any mental reservation
or purpose of evasion,
or purpose of evasion,
and that I will well and faithfully
and I will well and faithfully
discharge the duties
discharge the duties
upon which I'm about to enter.
upon which I'm about to enter.
Congratulations, Commissioner.
I
Thank you.
appreciate it. Thank you.
No, you have two more.
Congratulations, Commissioner Martz. And next is with oath of office of two reappointed commissioners. Zakia Wright first.
Come on down. So glad you're back. All right. Repeat after me. I state your name.
I, Zakia Wright,
Do solemnly swear
do solemnly swear
that while serving in the office
that while serving in the
as
office
a member of the Rent Stabilization Commission
as a member of the Rent Stabilization Commission
City of West Hollywood,
of the City of West Hollywood,
that I will support and defend
that I will support and
the
defend
Constitution of the United States
the Constitution of the United
and
States
the Constitution of the State of California,
and the Constitution of the State of California,
that I will bear true faith and allegiance
that I will bear true faith and
to
allegiance
the Constitution of the United States
to the Constitution of the United
and the
States
Constitution of the State of California,
and the Constitution of the State of California,
that I take this obligation freely
that I take this obligation freely
without any mental reservation
without any mental reservation
or purpose of evasion,
or purpose of evasion,
and that I will well and faithfully
and that I will well and faithfully
discharge the duties
discharge the duty
upon which I'm about to enter.
upon which I'm about to enter.
Congratulations,
Thank
Zakia.
you.
Thank you so much, Commissioner. All right,
And now it's my turn.
it's your turn. All right. Okay, and you'll raise your right hand and repeat after me. I state your name.
I, Agassi Topchin,
Do solemnly swear
do solemnly swear
that while serving in the office
that I'm serving in the office
as a member of the Rent Stabilization Commission
as a member of the Rent Stabilization Commission
of the City of West Hollywood,
of the City of West Hollywood,
that I will support and defend
that I will support and defend
the Constitution of the United States
the Constitution of the United States
and the Constitution of the State of
and
California,
the Constitution of the State of California,
that I will bear true faith and allegiance
that I will bear true faith and allegiance
to the Constitution of the United States
to the Constitution of the United
and the
States
Constitution of the State of
and the
California,
Constitution of the State of California,
that I take this obligation freely
that I will take this obligation freely
without any mental reservation
without any mental reservation
or purpose of evasion,
or purpose of evasion,
and that I will well and faithfully
and I will well and faithfully
discharge the duties
discharge the duties
upon which I'm about to enter.
upon which I'm about to enter.
Congratulations. Thank you so
Commissioner.
much.
Thank you. All right, thank you, Council Member. Thank you very much for administrating the oath of office. And congratulations to everybody, and happy to continue serving with you all and with our staff. Thank you. All right, so we're going to go back to our business, and now we are ready for a roll call, Ms. Secretary.
Yes. Commissioner Kerpes,
Present.
Commissioner Martz,
Here.
Commissioner Wright,
Present.
Chair Topshin.
Here, so we have a roll call, we have a quorum. Four commissioners are here, we have a quorum. And the next item is the approval of agenda. Has anyone had a chance to review the items before us tonight?
Motion to approve.
Second.
Okay, we have a motion to approve the agenda, and the second, Ms. Secretary, we have a roll call. May we have a roll call, please?
Yes. Commissioner Kerpes,
Aye.
Commissioner Martz,
Aye.
Commissioner Wright,
Aye.
Chair Topshin.
Aye. Motion carries. Thank you. The next item is approval of minutes. We have the minutes for the meeting on April 13, 2023. Well, it was a long time ago. Has everyone had a chance to review the minutes?
Motion to approve the minutes.
All right, we have a motion to approve the minutes.
Second.
And second, Ms. Secretary, may we have a roll call vote?
Yes, Commissioner Kerpes,
Aye.
Commissioner Martz,
Abstain, I was absent.
Commissioner Wright,
Aye.
and Chair Topshin.
Aye, but would this be enough? Okay, all right, so then motion carries. Thank you. Public comments. Do we have any speakers from the public? All right, we have Council Member Chelsea Byers.
I just wanted to come and say congratulations to you all again. I feel really honored that I got to swear in the entire commission tonight. So as part of that, I'm going to insist I take a quick selfie, if that's okay.
Oh, that would be great.
Thank you. Amazing. But I truly just want to say it's a real honor to be standing before you. You all have tremendous experience and leadership in this city. It's no surprise that you're all back here again for more, and I just want to really commend you all and thank you for your commitment. This body meets more than any other body on a regular basis, so long as there are hearings, and I just thank you for the intricacy, the importance of your work. The tenants of this community are who I personally ran to represent in the biggest way possible as one myself, and I just thank you so meaningfully for your work. So you're the only body I actually stood to stay around for public comment to thank after I swore you in, but it really meant a lot to do that tonight for the four of you. So thanks so much, and I hope you have a great night.
Thank you, Council Member, for being here tonight. Thank you. Other speakers?
No other public comments.
No,
at
we
this
don't have
time.
any public comments at this time. All right, so then we're gonna move on to the manager's report. Rent Stabilization Manager, Mr. Jonathan Holub is here.
Thank you, Chair. Good evening, Chair, Commissioners. Jonathan Holub, Rent Stabilization Manager. It's good to see you after so many weeks, and congratulations on your really reappointments, but appointments from different sources, and I'm so happy that you'll all be serving and that the staff can work with you for another term. So tonight we have two appeals. The appeal calendar will be changing a little bit. There won't be an appeal next meeting, but we do have agenda items that the Commission has to address, specifically the announcement of the annual general adjustment and other adjustments that need to be made on an annual basis. Then after that, we'll resume. There will be two appeals at the subsequent meeting, and the schedule beyond that might change a little bit, but it will be a packed summer, I assure you. During the hiatus, the City Council adopted the amendments to the RSO that you considered earlier this year, including an expansion of the on-site manager requirements, prohibition against dog breed restrictions, and requirements for acceptance of reusable tenant screening reports by landlords. In addition, the division is in the process of completing the registration of non-rent stabilized rental units and hopes to have most properties that are subject to the new requirement in compliance by the end of June. We've talked in the past about the eviction rates that we get from Betsetic, so just to give you an update on that, there has been an uptick, and since the county's tenant protections expired at the end of March, it wasn't quite as much as could have happened. So at the moment, it's up, but not even doubled on a monthly basis, which is encouraging. I don't think we'll have a full sense of what the impact is until a few months out when we see what it really looks like after several months. Also, not surprisingly, the number of Ellis filings is well above average because there was a moratorium, so the backlog has caught up, but it's not really more than we would have expected. It sort of is what we would have anticipated during the 3 years of the pandemic, that they weren't going forward. So, it's never an easy situation, but nonetheless, that's where we are. So I want to remind tenants who are experiencing hardship, though, that there is potential assistance available. In addition, tenants who are under threat of eviction may utilize the no-cost legal services through BetCetic. For information about these programs, contact the division at 323-848-6450 or rsd@weho.org. Folks can also schedule for an online or in-person appointment, and they can do that by just visiting weho.org, going to the search icon, and then there's a button for scheduling an appointment. And that's a good way to make sure that you're promptly served. So I encourage people to do that.
Thank you.
Any questions?
Let's see if the commissioners do have questions. Yeah, go ahead, please. Commissioner Wright and then Commissioner Curtis.
Would staff be, amenable to like adding an attachment to the end of our agendas that has like a summary of like the Ellis filings, sort of the numbers that we have? And I know it probably won't be real time since it seems like we probably get them maybe quite a few weeks or months afterwards, but just so we sort of know and maybe can sort of track like what the trend is and just keep an eye on that.
I can do that.
Thank you.
Yeah, go ahead.
And then I had a question about, do you happen to know approximately how many Ellis or tenants are being Ellis right now? I know that there's probably quite a handful of buildings, but do we know how many like units are in each? So,
When I last checked in with staff on the issue, I was told about 50 tenancies are being displaced as a result of Ellis.
so like within the next, is it 90 days or 6 months or what?
Well, it's 120 days normally. Many are extended through a full year because if you're disabled or senior, you can take a full year. And oftentimes, since the landlord isn't really removing the property from the market, they'll allow the other tenants to stay as well. They don't have to, but they can, and that's often what happens.
Because it just seems like, with that, even though the numbers, as you said, it's not anything unusual because of the number of years that they've been under a moratorium, it's a lot of tenants that have to find new places now. So, thanks.
Commissioner? All right. Mr. Holub, I remember a couple of months ago, you mentioned that the council, the unit swap issue will go before the council. I mean, not the issue, but the ordinance. Can you update on that? Is there anything?
There's no pending item before council. There's legislation in Sacramento right now, AB 1620, and the city is a sponsor of that bill that addresses that issue through a proposed amendment through Costa-Hawkins.
Okay.
So it did pass Assembly, and it's in Senate rules right now. So they're deciding which committee it will go in front of in the Senate.
All right. I guess in the future, if there's any development, you will bring this up.
For sure.
Thank you. All right. I guess we don't have any further questions at this point. At this time, I'm going to ask the commissioners if you have any comments. Anything you would like to share? Nothing. All right. So that brings us to the appeal section of the agenda. And we have two appeals before us this evening, and it appears that both appeals have to do with the determination of the maximum allowable rent and overcharges in rent. And both appeals pertain to the same property address, 1236 North Flores Street, although different units. And both appeals have been filed by the landlord. So the first case, the first appeal we're going to hear is the appeal application D-4714 that pertains to unit number 202 of the subject property. The first I'd like to confirm is, Ms. Secretary, do we have the representative for the tenant and the landlord tonight present?
The landlord is present, and the tenant for D-4714 is present, and the tenant for D-4716 has not joined. They did request the Zoom link, but they did mention that they were going to be working. They were provided with an email with my email address, and they would be reaching out if they were not able to attend. So I'm monitoring that, and they were aware that they were the second appeal on the agenda.
All right. Okay. Thank you. And any speakers other than the appellant or respondent?
No other speakers.
No other speakers. All right. So before we begin, I'd like to take a moment and explain the appeal process for the appeal. First, the commission will hear a staff report presented by the legal counsel, and then an oral argument will be next. And the appellant, who in this case is the landlord, will speak first. You will have 5 minutes to present your case. You have the option of dividing your 5 minutes into 2 segments. You may use part of your 5 minutes to state your case and part of the 5 minutes for rebuttal. As for the respondent, the tenant will speak second, and you will have only 5 minute segment to present your case on the appeal subject. You will not be able to divide your time. When it is time for you to speak, please come to the podium and state your name and city of residence for the record. And the appellant will state how you would like to divide your time, if at all, and proceed with your comments. All right. As a reminder, since your time is limited, it is important for you to keep the following things in mind. Make sure that your comments are on topic. The only information you want to share is the information about your appeal topic. And the new evidence cannot be considered by the commission. You may only discuss issues that were raised at the hearing or evidence that was submitted to the hearing examiner. And you may be interrupted if you go off topic. With that said, I will ask the legal counsel to present the report.
Thank you, Chair, and good evening, Chair and Commissioners. My name is John Natalizio. I am the legal counsel to the Rent Stabilization Commission for the City of West Hollywood. This appeal was filed by the landlord in response to the hearing examiner's decision determining the maximum allowable rent and overcharges. This appeal specifically focuses on the hearing examiner's decision determining that a fee charge for master metered water and gas was unlawful. In addition to tenant's rent, tenant paid a separate $30 utility fee for master metered water and gas. Tenant received a notice in July of 2022 that the utility fee would be increased from $50 a month to $100 a month. And relevant to this appeal, the hearing examiner determined the following issues: that the landlord had raised the rent higher than the permitted AGAs authorized, that the landlord had charged a separate unlawful utility fee for gas and water, and that the landlord had retained excess rent in the amount of $6,924.55. The landlord submitted an appeal which claims that the decision is not reasonably supported by the findings made or evidence in the record. Staff finds the decision is supported by substantial evidence. Regarding the maximum allowable rent, or the MAR, the hearing examiner correctly determined the base rent. The hearing examiner correctly identified the authorized AGAs and correctly calculated the MAR for the unit. Regarding the overpayment of rent, the hearing examiner correctly addressed and applied the applicable MAR to the amounts actually charged to the tenant. And regarding the water and gas utility fee, the hearing examiner correctly concluded that the RSO prohibits landlords from imposing a separate fee for any utility service which is billed directly to the landlord by the utility provider, which includes master metered utilities. Additionally, the city has always interpreted the definition of a housing service to include master metered utilities. Therefore, staff recommends adopting Resolution RSC 23-626. You as the commission have the power to modify, reverse, affirm, or remand the appeal decision of the hearing examiner. The commission reviews the hearing examiner's decision under the substantial evidence standard, which requires the commission to make sure there is substantial evidence that reasonably supports the hearing examiner's decision, is credible and of solid value. If that evidence is found, then the decision must be upheld, even if there's also evidence that could support a different outcome. The commission does not substitute its judgment for that of the hearing examiner or reweigh the evidence. As it relates to questions of law, the commission applies an independent standard of review to the hearing examiner's conclusions of law. Thank you.
All right, thank you, Mr. Natalizio. Commissioners, are there any questions for the legal counsel? All right. Okay, so then I'll open the oral argument portion of the appeal and would like to invite the landlord to the podium. Good evening, sir. You will have 5 minutes to present your case. Before you proceed, please indicate if you'd like to divide the time.
No.
You'd like to take the 5-minute segment. All right. So please begin by stating your name and the city of residence for the record.
My
and you
name
may...
is Derek Boise and reside in the city of West Hollywood.
Yeah, you can begin your comments.
Okay. I'm not here to argue anything. I'm just here to deliver a statement on behalf of the landlord, which is as follows. I'm here to represent the landlord who disputes the city's ruling and to convey that if the city continues with its position in favor of the tenants, then the landlord will have no other choice but to file a lawsuit against the city for tortious interference or intentional interference with contractual relations. Please note that a defendant is liable to pay damages in tort for actions intended to interfere with the plaintiff's contractual relations with a third party. Noting thus far, we have the following to support the landlord's claim. 1, a valid contract exists. 2, the city and rent stabilization has been informed the contract exists. 3, the defendant acted intentionally and improperly. 4, the plaintiff was injured by the defendant's actions. The common law is what we all need to be considering at this time, which perhaps supersedes the city of West Hollywood's legislation, noting, I would say, on behalf of most, if not all, West Hollywood landlords, that the city's lawmaking is often unfairly in favor of tenants and against landlords, making the city an undesirable location for multi-tenant property owners. Let it also be conveyed that not only is the landlord going to sue the city, the landlord will also hold the tenants responsible for breach of contract if the landlord's appeal is denied. Thank you all for your time.
All right. Thank you, sir. Commissioners, are there any questions to the landlord? All right. Thank you. Okay. With that, I'm gonna invite the respondent, the tenant. Please come, sir. Please come to the microphone, and also you will have 5 minutes to address the commission, and you may begin once you state your name and the city of residence for the record.
Yeah, my name is Mark Andrew Tapia, and I'm a resident of the city of West Hollywood. And I realized that the landlord is threatening all sorts of things right now, and that's the way the appeal has been structured. I already submitted something to the city previously, and staff basically supported all of my contentions. In particular, they didn't specify any grounds on which they were appealing. They provided very little detail about the whole thing. They said it was a contract, and then it wasn't a contract. They said it was a utility fee, and then it wasn't a utility fee. It was really bizarre. The end result is that the staff agreed with my contention and said that it was not a valid fee to levy on the property and on my tenant. And I must add that there was a mistake, and they corrected that during the meeting, and it was that I had a fee of $30 per month, which was then raised to $100. There are, however, tenants in a building that pay no fee whatsoever. I don't know what else to add. I just find it distressing that they're threatening to sue me for breach of contract.
All right, sir. That concludes your comments?
Yes.
All right, thank you. And let me, just hold on a second, sir. We have Commissioner has a question for you. Commissioner Kurpis?
Yeah, thank you for testifying this evening. So you paid $30, at the beginning of your tenancy, you paid $30. That was the agreement. There was a lot of talk about $50, but you never
that
paid.
That was sent out a general notice to all the tenants, but.
Okay, but you paid 30 and then 100. Okay.
That's correct.
All right, thank you.
Thank you, sir. There are no more questions? Commissioner Wright has a question.
Okay.
So in your original application, there were about 9 or 10 issues, and then it got whittled down to those 2. And we don't have a lot of notes of what happened during the hearing, so I'm just curious if, like, why or how the issues were sort of decreased down to 2.
Oh, well, I just decided it was more reasonable just to talk about that particular fee because that was the most egregious thing.
Perfect. Okay, thank you.
Okay.
Okay, thank you, sir. You may
Is that
have
it?
That's it. Yeah, you
Okay.
may have a seat.
Thank you.
All right. Okay, so that concludes the oral argument for this appeal case. And commissioners, if you have any questions for the legal counsel, this is the time. Otherwise, we may begin our deliberation if who would like to begin. Commissioner Kerpes?
A question for legal counsel. It's my understanding that and I'm not arguing, advocating for one side or the other in this case, but I just want to get some history behind the ordinance that doesn't allow for utilities on a on a master meter setup. It's my understanding that the reason why the city would want to prevent that is so that a landlord couldn't sidestep. Well, first of all, no tenant knows exactly how much they're using of the 100%. So it could be, if every tenant was issued a different dollar amount, it could feel unfair, create problems that way. But also, it's a way for the landlord, or it could be a way for the landlord to circumvent the rent increases annually and say, oh, well, the water went up, everyone has to pay $5 more, or your tenants, your unit's using more water, so I'm going to charge you more. That's what I understood the basis for why we have that ordinance in place. I think that the way it was interpreted in this case, I don't know if I fully agree with the way it was interpreted in this case, in that this was an agreed upon specific dollar amount in the very beginning. I'm only talking about the very beginning of the tenancy. I'm not talking about any increases afterwards. But the $30 at the beginning of the tenancy, it seems a little just semantics, whether it was rent, part of the rent, initial rent or not. I know that the landlord didn't set it up very well in terms of, he basically almost took this law and said, okay, how can I not comply with this law? I'm going to separate it and say it is for utilities, it is for this, it's not part of rent. And that argument carried through to the end. But had it just been a side, like I'm just thinking about other landlords out there that do this, that have always just charged $30, for example, and are still doing that today, never raised it, or if they did raise it, they raised it with the rental AGA annually. I guess, I don't know really what my question is. It's, am I completely off base, I guess, in understanding that was the purpose and the reasons behind the law? And even if that was my understanding, is this law so clear that it doesn't leave any room for interpretation like that? Thank you.
No, I think your understanding of the history of the ordinance is correct. I think one of the other things, though, that was a factor in its adoption is to prevent wild swings like we're seeing in this case. Like, this is a very good example of why this was codified. The city's interpretation. Well, let me just back up. What that ordinance did was codify the city's already interpretation of a housing service. And the reason why master metered utilities was considered a housing service was because it was something that was provided by the landlord, unlike a sub-metered utility where the tenant is paying directly to the utility the cost associated with their direct use of a utility. And it wasn't something that was paid for by the landlord, and the landlord wasn't responsible for paying it. And so I think the big part that's missing is the fact that it was intended to also help prevent these swings by a landlord from saying, well, you know what, now we're going to charge this higher amount. And I think, and I understand what you're saying. I mean, I disagree with it because I think the exact reason why the interpretation of a housing service as well as the codification of it is to prevent this exact scenario. And while the situation you provide of like, well, isn't it just semantics? And I don't think it's semantics because right now we're seeing it play out and it isn't just a part of the rent, and they did raise it separately from the rent. and so it isn't just semantics. I think that if it was a part of the rent, there's no reason to specify it. They should have just had a rent amount that was $30 higher or $50 or whatever it is. And now what we're seeing is that there were AGA increases, and then there were also separate utility increases. So your understanding of it is correct in terms of the history of the ordinance, but I would disagree with your assessment of just semantics.
Thank you. Commissioners? All right, I don't see other questions. Well, let's then begin our deliberations. So who wants to begin? Commissioner Marth, maybe?
I think this is one of the more clear-cut cases that we've seen of a MAR case, and I think staff has correctly analyzed this matter. I think legal counsel explained the separation of the utility fee from the rent very clearly and why that's not allowed under our municipal code. And I apologize if this was already stated, but one of the other reasons that I see in my legal practice of why we do this is that if they're all lumped together and we don't have them separately metered, you can be paying for, the person who lives next door that uses way more. Just another reason. I think a lot of what our laws were designed for is about fairness and accuracy and allowing people to kind of know ahead of time what they're going to have to pay, as opposed to being surprised by swings. And I think this is a very clear-cut case. There was a rent listed in the lease and there was a fee listed, and those are separate. A fee is not permitted under our municipal code. To the landlord's representative's statement, that was literally reading the jury instructions for intentional interference with a contractual relation. I will leave that up to our legal counsel to deal if and when that comes about. I don't think that's the best way to get your point across or to prove your point. What we look for tonight is an explanation of why maybe staff was incorrect in their analysis. Threats don't move me left or right, but I just think, you have 5 minutes. I think that's a waste of your time, and it was a waste of your time this evening for my perspective. So I am very comfortable with how staff has analyzed this. I've read through everything, and I think it's accurate. So I'd uphold the hearing examiner's decision here.
Thank you, Commissioner. Commissioner Kerpis?
Thank you. I would agree. This is, other than the conversation that I had with legal counsel just now, I think this is a clear example of why this law is in place, because this is that law was intended to specifically address this type of issue where the landlord is trying to subvert or go around the AGA to make the increase. And the tenant, I agree with my colleague that it was a waste of the appellant's time to read to us this threatening statement. In fact, I would say most of it was completely irrelevant to the issue at hand, and I wish he would have addressed the issues more directly in front of us this evening. But I think this is a clear-cut case where the landlord was wrong, and the hearing examiner did make the correct decision, and then also, as far as I can tell, I would agree with staff that they also correctly calculated the overpayment. So I would be in favor of supporting the hearing examiner's decision.
Thank you. Commissioner Wright?
I don't, have any issues or see that there were, anything sort of questionable about how the hearing examiner got to their conclusion, excuse me, or the summary provided by staff. The only thing I sort of noted as I was reviewing the municipal code, looking up, utilities and sort of the references to the utilities in the code, and I did see a section in there that I thought could be applicable. And so I think the only sort of recommendation or whatnot that I would want for our hearing officers to be, sort of sure of is that they are analyzing anything that could be applicable, so that way we are making sure, should it come to, further litigation or whatnot, that the city has, been fully protected and fully evaluated sort of all of the applicable provisions. But other than that, I think the hearing officer reached the correct conclusion here.
Thank you, Commissioner. Well, I don't have a lot to add to what commissioners already have said. I agree that this is a clear-cut case when we have the maximum allowable rent determination based on the AGAs, the annual increases, and clearly the rent stabilization ordinance prohibits the landlords from imposing a separate fee or charge for any utility service which is billed directly to the landlord by a utility company. So if this was allowed, that would be basically circumventing the RSO and allowing a higher increase than that is permitted under the RSO, under the AGA increases. So therefore, I see that the examiner's findings and determination is correct, and also in terms of the calculations that are provided, the rent overcharges. So I agree with the examiner's determination and the staff's recommendation in this matter. So with that, if anyone would like to entertain a motion. Commissioner
Yes,
March?
sure.
Mm-hmm.
I will make a motion to adopt resolution RSC 23-626, a resolution of the Rent Stabilization Commission of the City of West Hollywood affirming the hearing examiner's decision as to the rent decrease for application D-4714.
Thank you. We have a motion, and we have a second by Commissioner Kerpis. Further discussion on motion? If none, Ms. Secretary, we are ready for a roll call vote.
Commissioner Kerpes?
Aye.
Commissioner Martz?
Aye.
Commissioner Wright?
Aye.
Chair Topshin?
Aye. Motion carries. Thank you. And if you have any questions to the parties, the tenant and the landlord, you may approach our staff after the meeting, and they will help you with the questions. All right, that concludes our first appeal, and we're going to move on to the next appeal for the same property located at 1236 North Flores Street, unit number 205, an appeal application D-4716. Ms. Secretary, I know that the landlord is present. What about the tenant?
The tenant is not present.
It's not present. What happens in a case like this? Waive the landlord?
Yes, so Chair, even though it's the same landlord, same building, same kind of issues, the commission treats it as a completely separate matter. So all deliberation, all facts from the previous case go, and then this case is as if the other one didn't happen.
Okay, thank you. Thank you for that. And with that said, let me confirm if there are any speakers for this case besides the landlords.
No other speakers.
All right. So then we're going to follow the same procedures. I'm gonna ask the legal counsel to present the staff report, and after that, in the oral argument part, we will allow the landlord to, who is the appellant, is in this case as well, to present the case. We'll have 5 minutes, and you may, if the tenant will join at the time, so then the tenant will have his or her portion, the 5-minute segment. Otherwise, we're going to only hear the landlord's part presentation, and then the commission will make a decision. So with that said, Mr. Natalizio, we're ready for your report.
Thank you, Chair and Commission. Thank you again for listening to me. My name is John Natalizio. Again, I'm the legal counsel to the Rent Stabilization Commission for the city. This appeal was filed by the landlord in response to a hearing examiner's decision determining the maximum allowable rent and overcharges. And this appeal specifically focuses on whether the hearing examiner's decision determining that a fee charged for master metered water and gas was unlawful. In addition to tenant's rent, tenant paid a separate $100 utility fee for master metered water and gas. Tenant received a notice in July 2022 that despite already paying a $100 utility fee, the utility fee would be increased from $50 to $100. Relevant to this appeal, the hearing examiner determined the following: that the landlord had charged a separate unlawful utility fee for gas and water, and that landlord had retained excess rent in the amount of $1,400. Landlord submitted an appeal which claims that the decision is not reasonably supported by the findings made or evidence in the hearing record. Staff finds that the decision is supported by substantial evidence. Regarding the MAR, the hearing examiner correctly determined the base rent, and because tenant's rent was never raised and the unit was not re-registered, the hearing examiner correctly determined that the MAR for the unit is the base rent. Regarding overpayments of the rent, the hearing examiner correctly addressed and applied the applicable MAR to the amounts actually charged to the tenant. Regarding the water and gas utility fee, the hearing examiner correctly concluded that the RSO prohibits landlords from imposing a separate fee for any utility service which is billed directly to the landlord by the utility provider, which includes master metered utilities. Additionally, the city has always interpreted the definition of a housing service to include master metered utilities. Therefore, staff recommends adopting Resolution RSC 23-627. You, as the Commission, have the power to affirm, reverse, modify, or remand the appeal decision of the hearing examiner. The Commission reviews the hearing examiner's decision under the substantial evidence standard, which requires the Commission to make sure there is substantial evidence that reasonably supports the hearing examiner's decision, is credible and of solid value. If that evidence is found, then the decision must be upheld, even if there is also evidence that could support a different outcome. The Commission does not substitute its judgment for that of the hearing examiner or reweigh the evidence, and as it relates to questions of law, the Commission applies an independent standard of review to the hearing examiner's conclusions of law. Thank you.
Thank you. Commissioners, do you have any questions regarding the report? All right. I've seen none. With that, I'm going to open the oral argument segment of this appeal, and first we're going to hear the landlord's argument. Sir, you may come up to the microphone, to the podium. You will have 5 minutes, and since we don't have the tenant at this time joining in, so you have the 5-minute segment.
That means I get 10 minutes, right? I get his 5.
No, there will be 5 minutes, but you don't have to divide, of course, the time, obviously. So just state your name and the city of residence for the record.
My name is Derek Boise, city of residence, West Hollywood.
Okay, you may begin your comments.
As you know, this is the same building, same landlord, just different tenant, but same issue, right? So I read the landlord's statement, which is the same applied to this case, but I would like to add that the appeal response, I believe, included that the utility fee was a fixed finite amount in the lease form. Had the landlord not called it a utility fee and just made the rent $100 higher, we wouldn't be here right now, right? I mean, based on what I've heard today, on your analysis of the law. So this is not just one case, this is an epidemic, and the city is really gonna hurt the landlord economically. So the landlord is gonna definitely pursue torturous interference or intentional interference with the contract. I'm not an attorney, I'll leave that to the attorneys. So if the utility fee wasn't called the utility fee and it was just added to the rent, which the landlord didn't structure his lease in bad faith, obviously he made a blunder based on your analysis, right? So there is no attempt of circumventing the RSO to have hidden increases. Maybe the increase to the existing fee in the agreement was incorrectly applied by the landlord. Had he applied just the standard approved city 2 or 3% for that year, probably we wouldn't have an issue. So this isn't just about these two cases. There's 32 tenants in that building that are going to be marching in here with the same case, and you're going to be penalizing the landlord 32 times, and that's a lot of damage if you do the math. And I think the landlord's going to definitely pursue legal action for those reasons. So I don't know how to advise anybody. certainly not the landlord or the city. But I just wanted to share some color of how the contract was laid out and why the landlord believes it's interfering with the contract if you keep ruling against all these leases. Now, in good faith, all subsequent leases, the landlord has instructed the leasing department to remove that fee as delineated as such and just increase the rent $100, right? Now, the reason the tenants have different, Mr. Tapia, his $30 fee was because he's been a tenant for many, many years. So at that time, the fee was X. Now, the new leases, the fee is $100, right? That's what the landlord was doing in good faith. So now we have orders to just increase the rent $100 and just don't make reference to a legal fee. And it's, I guess, hidden now inside the rent, but you guys can't penalize the landlord because it's not being mentioned as such. So that's sort of the mockery of the whole analysis, right? If it wasn't there, we wouldn't have this issue if the landlord just called it rent and that paragraph 2 or whatever it is instead of paragraph 4 utility fee. So that's just, those are my thoughts that you should consider as well, because I'm going to have to be a witness at the lawsuits, and it's just waste so much time, everything. So thank you very much for your time.
Thank you, sir. Commissioners, yes, please, Commissioner Kerpis.
I do have a question for you.
Thanks.
So we've heard testimony, or I should say we read testimony that the letter was sent out asking for an increasing it from 50 to 100. Now we've heard from one tenant in a previous case tonight that his was 30 and was going to 100, and now we hear from what I read in the case, this person was paying 100 and it would have stayed at 100. It seems to me that the landlord doesn't quite explain this letter. Why was it so wrong in the two cases that we've seen tonight?
There was a boilerplate letter that went out about the utility fee increase, which the landlord believed was lawful and he believed he was entitled to, especially with the economy the way it is and inflation. All of the operating costs for the landlords are going up. So
my question is about the letter, though.
Right. So that letter was a boilerplate letter mistakenly sent to some tenants, not referencing their starting. Like if one tenant, his lease was 8 years ago, and he's paying $30, the increased letter mistakenly said your $50 utility fee is now going to be 100. So it was a mistake from the clerical.
So was the intent of the letter to raise everybody's to 100 regardless of what they were currently paying? Some were already paying 100, some were paying 30.
Yeah, so the ones that were already paying 100, it didn't apply to them because their leases are new. So I think the only damage is here that, if there was a compromise, would be to award the gap and to let the original fee remain, the $30 or the $50 or the $100 or whatever is in that original lease. If this is going to continue to be a legal conflict, then maybe just say that the increase.
I understand what you're talking about.
The increase was not right.
Yeah, you're no longer answering my question, but I do understand what you're saying. I appreciate that. Thank you.
Right, thank you. Other commissioners, questions? No. All right, sir. Thank you.
Thank you.
Thank you for your statement. Okay. Since we don't want to, you want to say something? No. Okay. Since we don't have a tenant, the tenant didn't join the meeting. Therefore, I'm going to close the oral argument, and we will move on to the commissioner's comments or deliberation. Yes, please, Commissioner Martz. Oh, I'm sorry. I didn't. Thank you, Ms. Natalizio.
No, thanks, Chair. I just wanted to address just a couple things and that were said just from a legal perspective. And one is that, yes, what should happen is that the rent should include all master metered utilities that are going to be provided to the tenant. And this is because landlords are allowed to charge market rate when there's a vacancy. And so that market rate unit amount should be inclusive of what the landlord anticipates is going to be costs associated for master metered utilities. And I think the landlord's representative just saying, well, it's, again, just semantics. If they just put that $100 into the rent amount, we wouldn't be here. Well, we also wouldn't be here because in the situation of the prior case, that rent only would have been $30 more, and the landlord tried to raise that utility fee to 100, in addition to separate rent increases. So it's a little bit of a two-faced argument, I think, that's being made. And lastly, I think that the evidence in their record, particularly if you look at that increased notice for the utility, it is very clear that the increase is for the claimed increase in associated costs for providing the utility. It's very clear that rent can only be raised by the AGA, and so a landlord couldn't raise the rent by $100 just because they feel that the utility fees have raised that much. So I think that it's very clear that that utility fee was intended to account for the utility fees associated with providing it to the tenants. I don't think it was malicious or intentional by the landlord. I think it was just a mistake, but under the RSO, tenants can't contract away their rights. So it doesn't really matter what the lease says. If the RSO prohibits it, a tenant could agree to it, but it doesn't make it valid. That's it.
Thank you. Thank you very much. All right, Commissioner Wright, you would like to begin the deliberation?
I think I certainly have, sympathy and empathy for sort of the landlord's plight now. I think, to the point that he made that there are going to be likely other tenants that come forward, for this adjustment. And I think, sort of regarding whether it's included as utility, whether it's, added to the rent, at the beginning of the tenancy, I think it's something certainly that the landlord has learned a lesson on in a very hard way. And again, I'm very, sympathetic to that. I don't believe that, there were any issues with the decision that the hearing officer made. I think the calculations appear correct and in line with the rent ordinance. And so I would, vote to affirm the resolution.
Thank you, Commissioner. Commissioner Corpus?
I would agree with my fellow commissioner. I think that there are other ways that the landlord can recoup expenses if the cost of running the building is more than what the revenue is, and that's a whole different process, and maybe that's a process that the landlord would want to look into. But malicious or not, the landlord made a mistake in the very beginning by delineating it. I could easily overlook that, but the steps that the landlord then took over the years to increase, not only attempt to increase the rent, but also separately increase that fee is exactly what this law was established for. So again, I think this is a perfect example of why we have this law in place. And I'm sorry that the landlord is learning through this process and has many more, I guess, tenants that are in the situation, but that is the law. And so at the end of the day, if after he's reimbursed everybody and he's not making enough money on the building, there's a process for that, and he can come back to the city and look into the possibility of raising rents across the board to make up for that difference.
Thank you.
I will be voting to support the hearing examiner's decision in this case as well.
Thanks, Commissioner. Commissioner Martz?
Yes, I think Mr. Natalizio, legal counsel, explained most of the comments that I was going to make. I'm just going to say the landlord, your problems and not understanding the law in West Hollywood are not the problems of your tenants. That has nothing to do with the law. If you can't follow the law, that is not a problem of this body. We're here to enforce and interpret the law. There were a lot of specious comments made by the landlord's representative. A lot of them made no sense. I'm a little flabbergasted that they were being thrown at us because it's embarrassing for the landlord. As to a lawsuit, I won't go too deeply into it, but it's a bunch of garbage because a contract has to comply with the laws, and this law has been on the books for a long time. So when you enter into a contract, you have to make sure you're following the law with the contract that you are entering into. So go ahead if you think that we are making a mistake here and sue. You would be wasting your attorney's dollars, your time. It's you testifying is not a waste of your time on our behalf. It's your own time that you're wasting because we're interpreting this correctly. So I think the hearing examiner made the correct decision in this case as well as the last one, so I would uphold that decision.
Thank you. I'll be very quick and just mention that as I stated in the prior appeal that the rent stabilization ordinance allows the increase of the MAR maximum allowable rent annually, and the RSO also prohibits the charges for the separate fee for the utilities that are billed directly to the landlord, so that is considered as illegal rent increase in a sense. So the landlord's argument that the inflation, and the expenses that the landlord has, I understand, and also it's tough to be a landlord in a rent stabilized city, but we have a strong ordinance that controls the rent, and that's the whole purpose and the intent of the RSO, to control the rent. We don't set the MAR. I mean, the RSO doesn't set the maximum allowable rent, doesn't set the market rate, but the RSO controls the market rate. Basically, when the unit becomes available and at the time the tenant and landlord negotiate the base rent, and the landlord sets the market rate. So in this case, the market rate, the base rent was $2,295. So the landlord could have just add $100 extra and make it $2,395 instead of $2,295. So there won't be any issues here tonight. So therefore, the argument that there is inflation and the expenses the landlord has to meet, and that's why the increase was justified, that's very incorrect information, and I wish the landlord at the time of initiating the rental agreements, the landlord had an idea about the RSO. So the thing about these rent stabilized jurisdictions, and that there is a strong ordinance that regulates the rent, as I said, and it's a good idea for any landlord. If you own a property and you're entering into that business, you need to realize this is a heavily regulated business. We have the local ordinance, we have the county protections, we have the state protections. You have to maneuver somehow. You have to navigate through that legal system, the laws. So that's why it's a good idea for any landlord to first, do the homework and basically learn the law and see what you can do. Because whatever the tenant signed, if that agreement is gonna violate or contradict the law, that agreement will be void. So it doesn't matter what the tenant signs. So in West Hollywood, if the tenant signs something that will be that will contradict the ordinance, that would not be that would be void. That agreement or that part of it. So therefore, I little deviated for what I wanted to say. It's just basically in this case, the examiner's determination was correct based on the review of the law, of the ordinance, and the documents presented, and the calculations were correct. And I would agree with staff's recommendation in this matter to affirm the findings of the examiner. With that said, anyone would like to make a motion?
Sure.
I move to adopt resolution number 23-627.
Thank you, Commissioner Wright. And
Second.
We have a second also. Any further discussion on motion? All right, Ms. Secretary, we're ready for the roll call vote.
Commissioner Kirpies?
Aye.
Commissioner Martz?
Aye.
Commissioner Wright?
Aye.
Chair Topshin?
Aye. Motion carries. Thank you. Thank you, everyone. And I'd like to thank also the parties present. And if you have any questions, you may approach our staff after the meeting, or you can call the Rent Stabilization Division and schedule an appointment to meet with the staff representative at, you can call at 323-848-6450. That's the Rent Stabilization Division. All right, so we don't have any appeals at this time. I'm going to move on to the next item on the agenda, which is the new business, and nothing scheduled under that. Item from staff, Mr. Manager.
Might learn to use this thing one of these days. Nothing from staff, thank you.
Nothing from staff. All right. Public comments? I doubt there are speakers.
No speakers at this
No
time.
speakers. All right. Commissioners, would like to?
Yes,
Okay,
I
please.
would just like to say I'm excited to be back with everyone. We had a long break. We have, you know, it's a cliche, but we have the city's people's business to do and a lot to work. I know we have a lot of appeals that are probably in the backlog, so I'm excited. I'm excited to see a potentially new commissioner, direct appointee, whoever gets appointed by the council as a whole, so we can be here as a whole body since we've had a few missed meetings because of quorum issues. So I'm just excited. It was a nice break, but it's good to be back. So appreciate it.
Thank you. Commissioner Kirkus.
Yeah, I just wanted to say I'm glad to be back. Sorry, my microphone keeps on going on and off. I too look forward to working with all of you and for this next term. Also, I noticed in tonight's, it raised a flag for me in tonight's case. I happened to read what the deposits had played, or what one of the tenants had paid in their deposit. It just reminded me, is there a deadline for tenants to seek from their landlord reimbursement for the interest rate from last year?
There's no deadline.
There's no deadline.
Yeah, they can submit the form at any time.
Okay, so if anyone's watching at home, I do want to remind people that if you have a deposit that your landlord is holding on to, last year was the first after several years of not having one, where an interest rate was established based upon the interest rates in the financial system. So you may be entitled to interest off of your deposit. So check in with the city or your landlord about that. And that's all I have.
Thank you. Commissioner Wright?
So it is Pride Month, and the city had an amazing kickoff last month with lots of events going on all over the city, and that'll continue throughout the month, as well as things going on in LA, Long Beach, all those places. So just happy Pride, everyone.
Thank you. Happy Pride. And I'm excited to be reappointed by Councilmember Lauren Meister, and I want to thank her for her trust in me. And I'm looking forward to working with everybody here and with our wonderful staff. And that concludes my comment. And with that, this meeting is adjourned until the next regular meeting of the Rent Stabilization Commission, to be held on Thursday, June 22nd, 2023 at 7 p.m. here in West Hollywood Park Public Meeting Room, Council Chambers. Thank you, everyone, and good night.